Mr. Armentrout?
May it please the court, counsel. The Grinnell Regional Medical Center did not receive a fair trial. After submitting substantial evidence at the time of trial of legitimate reasons to terminate Mr. Hawkins by the hospital, evidence that included physician complaints and issues with the lab and Mr. Hawkins' performance that predated any diagnosis of cancer, evidence that the district court even called at the time substantial evidence, the district court refused to give the same decision instruction to the jury.
Was this a mixed motive case, or was it a pretext case?
It was a mixed motive case, Your Honor.
Well, why in closing argument then, what did counsel for the hospital state there was no evidence of discrimination, no evidence of disability discrimination, no evidence of retaliation? It seems to me that the closing argument at least suggests that this was a pretext case.
Well, I think what determines whether it's a mixed motive case or not, Your Honor, is the evidence at the time of the trial.
Well, wouldn't closing argument kind of give you a suggestion of how the case was tried by counsel?
Well, I don't think you can let one party or the other label their case as mixed motive or the other. And the plaintiffs have traditionally labeled their cases as mixed motive to get that lower standard of motivating factors since Price Waterhouse.
And they got a Price Waterhouse instruction, did they not?
Absolutely. The motivating factor, mixed motive state. They requested a mixed motive instruction. The district court gave a mixed motive instruction, and the plaintiff's counsel argued it as a mixed motive case.
Maybe even more direct. It seems to me that both parties have gone back and forth on whether this is a pretext case or a mixed motive case. There's motions for summary judgment filed, and it's not entirely clear to me how the case was tried. Or maybe even it was both. So I'll leave it there and ask you to clarify, if you would,
Yeah.
please.
I mean, at the end of the day, what this court and the federal courts have said is when the decision is a product, if there's evidence of illicit motives, the discriminatory retaliation, and there's evidence of legitimate motives, that makes the case a mixed motive case. And when the district court decides to give a mixed motive instruction to the jury, you've got to look at the mixed motive analysis and standard at that time. And that's what happened here. The plaintiffs requested a mixed motive instruction. The court gave a mixed motive instruction. The plaintiffs argued it as a mixed motive case to the jury. They used an analogy of baking cookies, and if one of the ingredients is illicit, then the whole cookie is spoiled and there's a violation of the act there. And if you go back all the way to Price Waterhouse, when the Supreme Court first looked at mixed motive cases, part and parcel to the mixed motive analysis was the same decision instruction that went along with it. So, and in this case, the problem with the low motivating factor mixed motive instruction is that instruction 22 defined motivating factor as whether the plaintiff's age, disability, or engagement in protective activity played a part in the decision. And then the instruction went on to say these criteria need not have been the only reasons, meaning that there could be 1, 5, 10, there could be other legitimate reasons, but the jury need not consider them. That reduced the plaintiff's burden so low that even if 1% say of the decision was based on age or disability, the plaintiff prevails, and that is not the law in Iowa.
Has Iowa ever applied Price Waterhouse in a case? I mean, we've talked about it, but is there an actual case where we've applied it?
I would say yes. I mean, the land.
Okay, which case?
Well, the Randall's case is when the court in 1990 first adopted Price Waterhouse mixed motive analysis.
That was that was under the federal statute. That wasn't under the state ICRA. That was tried under the federal statute.
And since that time, in the Bowman case and in many cases with the Court of Appeals, and then this court's McQuistion decision.
That was dicta in McQuiston.
We talk about it in those cases, but we've never applied it. And there's some states who don't apply a mixed motive, who don't apply Price Waterhouse. They try all cases pretextual. I mean, you say in your brief it was applied in Iowa, but I couldn't find a case that said it was applied in Iowa.
I think that's what makes this case a case of first impression for this court to take a look at. I think this court has spent a lot of time, both in the DeBoom and the Haskinoff cases, taking a look at the plaintiff's burden. what it should be. Should it be played a part or not? In the Haskinoff case, I know there was a 3-to-1-to-3 split on whether in retaliation cases you should use motivating or significant factor. At the end of the day, 4 justices said it should be the lower motivating factor standard, and then Chief Justice Cady said what the instruction to the jury should be is not played a part, because that lowers the standard so low, it lowers it, in fact, too low. But what the Chief Justice didn't say in Haskinoff in his concurrence is what should the instruction be? We got to the point in this case where we were talking about in the instructions, and we asked the court a couple times to read the Haskinoff decision, and he very dutifully did so. And the next day he came back and said, you know, I read it again, and I'm still confused on this 3-to-1-to-3. I'm not sure what I should instruct on retaliation.
Well, I don't think a same decision instruction was requested at the Haskinoff trial, right? So here we are. What would use of such an instruction undermine the protections of the Iowa Civil Rights Act?
Well, I agree, Your Honor. In Haskinoff, the same decision instruction wasn't raised or considered, and I do think it's important that the entire mixed burden instruction be the analysis and the standard. Otherwise, you could be reducing the Iowa Civil Rights Act to a general code of conduct. If it's played a part and only 1% of the reason could allow a plaintiff to prevail, then general thoughts and comments could trigger liability. In fact, the California Supreme Court addressed the very same issue in Harris versus Santa Monica in 2013, which Justice Appel, you noted in your concurrence and dissenting opinion in Haskinoff.
What do you think of that approach?
Well, interestingly, Your Honor, and I have thought about that, the California Supreme Court said, you know, we think the initial burden shouldn't be played a part, it's too low, and they made it a significant factor, but then the California court required the same decision instruction as part of it, because the court said otherwise you'd trigger liability under the California Act for general thoughts and
But allowed an injunctive relief and attorney's fees recovery, kind of a
right.
mixed result.
And that's really the issue that's kind of left out here is what happens in those cases where the defendant does establish the same decision defense, you know, in those cases.
If this was a pretext case where we didn't have the mixed motive, some states don't adopt the mixed motive approach. Would the causation instruction be wrong if it was tried as a pretext case?
I think it would be wrong, Your Honor.
In what way?
Well, if we're going back to take a look at because of or but for determining type causation, then you're still requiring the plaintiff to come forward to show that at least 50% of the reason or the majority of the reason was the illicit or illegal conduct here, versus if you say it's going to be a motivating factor played a part standard, it lowers that standard down well below that stage. So I'd be happy if we'd gone back to a pretext type determining factor, but the court decided it was going to give the mixed motive lower motivating factor at the time of trial. And how that, not only is that we believe an erroneous statement of Iowa law, but the plaintiff's counsel took advantage of that lowered standard when she argued, for example, in the retaliation claim, one of the claims was that the plaintiff was retaliated against because of the filing of an Iowa Civil Rights Act claim. And
Is there instruction regarding pretext?
there was in this case.
And is it fair to say that the jury found that the asserted legitimate reason for termination was pretext?
Well, it's hard to say that from,
Well,
we didn't ask a special interrogatory to the jury about that.
There were both instructions given. You know, let me follow up on, you know, you use these percentage analogies and you say percent of this, percentage of that. We're really talking about causation, right?
Correct.
And the issue is really with the same decision defense is the same decision would have been made anyway. And aren't you really conceding that on their side, it could be 10%, it could be 30%, it could be 50%, but if it's the tipping, if it's the dispositive consideration without which the decision to terminate would not have been made, then they prevail, right?
Right. If you make the initial threshold or the definition of motivating, like you said, the determining factor or the dispositive factor, I know Justice Cady in his concurrence said, he cited with approval of the Hassan case, it said the decision that pushes the decision maker to the point of making that decision.
I realize the same decision defense shifts the burden to the employer to show that it wasn't the dispositive factor, but that's still what we're talking about, right? Isn't it? What's the tipping point, right?
Well, I think that is right, Your Honor, because if the defendant cannot prove the affirmative defense, then the plaintiff's going to prevail, even with a played a part instruction. And I'm sorry.
I was just going to ask you to address the whether the 4.2 million for emotional distress is excessive, and whether that may have been inflated by crossing the line in closing arguments.
Yes, Your Honor, we do believe it's excessive under the standards that this court has enunciated. Back in 2009 in the Jasper versus Nysum case, this court did a very thorough analysis of cases in which the plaintiff didn't seek or receive medical treatment for the emotional distress. And the court looked at what the court called the common consequences of job loss. And the court said at that time that $200,000 would be about the upper limit for a plaintiff with those kind of common consequences, absent harassment or sexual harassment or those kinds of things that would cause damages to be higher. And that's been the law in Iowa since 2009. We believe the evidence here really comports with Jasper versus Nysum. The plaintiff testified to those common consequences of job loss. He cried at the time, hugged his wife. He had some weight gain. There was some sleeplessness. He said there was some shame and humiliation, all of the factors that are under the Nysum case. The plaintiff had no medical treatment, sought no medical treatment or medications. There was no marital troubles that happened. There was no financial difficulty. And so in cases like that, it certainly seems obvious that the $4.28 million was flagrantly excessive. We do believe it was caused in large part because of the argument made by plaintiff's counsel at the end, in particular the golden rule violations that happened at the end. And of course our position on that, we know that the plaintiff's arguing that golden rule violations are okay if you're only talking about liability and not necessarily damages. This court has never drawn a line there. In fact, in the Kahn case, the Court of Appeals has said that it shouldn't be restricted to damages arguments. The problem with that argument in general is that the counsel's arguments went to damages. Even if we cited in the brief the many times counsel referred to the jurors as you and asked them to put themselves in the shoes.
Well, I mean, you or your appears a good number of times. We could count them up, I suppose. But it's kind of the royal you. I watched a show not that long ago. It was a cooking show, and put your butter in and put your flour in. And it is just kind of a manner of speaking. If you would have struck the you and said reasonable person, or struck the you and said one, I mean, it seems to me, and I want you to challenge, of course, that's why we're having the oral argument here, but it seems to me that the use of you or your is very contextual, and it doesn't necessarily mean, how much money would you take as a juror? Would $2 a day satisfy you, which is, I think, classic golden rule. But how much compensation do you get if you lose your job? I mean, that's not classical golden rule. It uses the term you. But isn't there contextual difference?
I think there probably is, and I've reread the various arguments, and if you look at the first part of plaintiff's closing argument, there's something that could be argued there that the royal you or the you was used in more general context. But here's what happened, though, and I'm not sure that we broke this down as well as we could have in the brief. It was towards the end of the argument, after counsel talked about liability, that counsel actually said, this starts at the appendix at 2005, I'd like to now discuss damages, and I want to discuss emotional distress. And she says, I'm going to give you an idea of how you can arrive at the right number. So she's now asking the jury to put themselves in a way where they can calculate emotional distress. And then she says, what is it worth to have your pride and dignity stripped away, to have your lifelong career snatched from you, to be discarded because you stood up for yourself? And then she said, back in the jury room, here's how you can figure out emotional harm. Hawkins heard about a lab meeting and sent an email. And then she looked up at the jury and said, can you imagine how it felt to type those words? Let that sink in. Can you imagine how it felt walking up those stairs to be terminated? Can you imagine how it felt the next morning? You know, those, I think, do cross the line, because that's no longer a royal you. That was a direct admonition to the jury to put themselves in the shoes of the plaintiff to award damages. I see that my time is up. I'd like to come back and rebuttal in a little bit.
Thank you, Mr. Armentrout. Ms. Carlson?
May it please the court, counsel. I'm Katie Ervin Carlson, along with Nate Borland, here on behalf of Greg Hawkins. In this case, the defendants are asking this court to make a monumental shift in the way the Iowa Civil Rights Act protects employees. Justice Waterman, if you'll notice, when defense counsel answered your question about will this change the protections of the Iowa Civil Rights Act, the answer was from the perspective of the employer. That, of course, is not the purpose of the Iowa Civil Rights Act. The purpose of the Iowa Civil Rights Act is to eradicate discrimination that this court has recently acknowledged is still alive and well in the state of Iowa.
All right, well, I'm going to start the same way with you as I did with your opposition. Was this a mixed motive case, or was this a pretext case, or was it both?
Well, I'm going to start my answer by saying the fact that we are having difficulty answering this question merely underscores how somewhat silly and convoluted that kind of legal framework has become in the context of employment discrimination. This case was and always has been a pretext case. When defendants moved for summary judgment, they argued that Greg Hawkins had to prevail under McDonnell Douglas in order to survive summary judgment. This court's precedent makes clear that there are two ways of looking at employment discrimination. One is the pretext analysis, where you prove your case under McDonnell Douglas and there's no same decision. The other is the mixed motives analysis under Price Waterhouse, and then there may be same decision available. I agree with you, Justice Wiggins. There's not been a case that has actually analyzed a case, an Iowa Civil Rights Act case under Price Waterhouse and looked at how that should be analyzed.
All right, so if this is a mixed motive case, you know, the opposition suggests, well, if it's a 1% factor in the mix, that yields liability. What's your response?
My response to that is that this court has made clear that we don't quantify motive when it comes to the Iowa Civil Rights Act. What they're asking you to do is reverse your decision in DeBoom and say, actually, we were wrong. Iowa Civil Rights Act cases shouldn't be proved using a motivating factor. They should be proved with a determining
But the
factor.
motivating factor came out of Price Waterhouse along with the same decision defense. And, you know, we kind of have, at least in the causation area, generally been tracking the federal Civil Rights Act laws. Isn't that correct?
The court has always looked at federal Civil Rights Act laws, of course, but has made clear that Title VII does not include the language of the Iowa Civil Rights Act that says our act must be broadly construed to effectuate its purposes.
But I'm sure that the federal courts would agree the federal Civil Rights Act should be broadly construed. Here's where I'm struggling a little bit. You know, generally in our legal system, for a plaintiff to recover from a defendant, even if the defendant was a bad person, had bad motives, had bad thoughts, we require that the bad result had to have been caused in a but-for sense by the defendant's bad thoughts or bad motives. Sometimes we'll shift the burden to the defendant to show that the event would have happened anyway, but the kind of pulling causation out the way you're talking about, that seems kind of foreign in general to our legal system, so help me with that.
I think what would be foreign, at least for cases tried under the Iowa Civil Rights Act, would be to require a plaintiff to satisfy but-for causation. This court has never said that that's what you have to do.
But to allow the defendant to show that the same action, the same consequence would have happened anyway. That's the same result, but it's just shifting the burden to the defendant. And isn't that what our legal system normally requires? I mean, I'm not an employment lawyer in my past background. This is not an area to me, but in torts and contracts, generally throughout our legal system, we require causation to be demonstrated. Either the absence of causation can be established by the defendant, or the existence of causation can be proved by the plaintiff. And to relieve that, relieve the plaintiff of that, seems to me, and to take that away, seems to me kind of contrary to the way our legal system normally works.
Well, I don't think you're relieving the plaintiff of anything. If the plaintiff proves that his termination was the result of an improper motive, be it discrimination or retaliation, then he has proved that his rights have been violated
I
under the
agree,
Iowa
but
Civil Rights Act.
you've now restated the jury instruction. That isn't what the plaintiff has to prove. It just has to prove a motivating factor.
Let me ask the question a different way.
Sure.
I'm sorry, Justice Mansfield, but if this was a pretext case, you said it was tried as a pre-case, was motivating factor the correct causation instruction?
Under DeBoom, which defendants concede is a pretext case, somehow they are distinguishing DeBoom from this case. But what that case said, the plaintiff said, you fired me based on my pregnancy. The employer said, no, we fired you because of performance issues. That is exactly the fact pattern we have in this case. So this is a classic pretext case. We came in and we didn't focus on testimony that suggested discriminatory motive. We focused on disproving all the reasons that they had given for why they had fired Greg Hawkins that wasn't his age, disability, or retaliation.
But my question is, if this was a pretext case, should the instruction been determining factor, or should it have been but for, or should it have been something else? I mean, that's the problem I'm having here, because sort of like what Justice Mansfield's saying, if you just have a motivating factor, it could be 1% on a pretext case, and you win.
Under DeBoom, this court said motivating factor is how you instruct the jury on a pretext case. Now, I think practically speaking, if a jury believed that discrimination was only 1%, but all the other reasons were valid too, they're not going to find for the plaintiff.
Aren't you required to show, in a pretext case, you're required to show that the asserted legitimate business reasons for termination were pretextual?
I think the instruction says something like, you can find pretext if you don't believe the defendant's asserted reasons. That's an instruction we had in that case, and that's not something that the defendants have appealed. So I don't think there's a disagreement about that.
Well, but my point, I was exploring this with other counsel. Has the jury made a determination that the asserted legitimate business purpose was pretextual in this case?
Yes, I think in entering a verdict for the plaintiff, they rejected the defendant's reasons. That's how they got there. You know, the defendants want to characterize this as substantial evidence and say that the district court found it substantial or significant. I mean, the district court judge used that word. I don't think he was giving it, I don't think he was saying how strong the evidence was. I think it was more a comment on how much defendant offered. But the plaintiff spent his entire case disproving each and every single reason the defendants gave, witness after witness after witness, and the jury agreed.
Is it harder for you to show that the legitimate business purpose was pretext, or is a same decision instruction harder?
In the way I read the cases, I think pretext is more difficult because you have to disprove what are otherwise, at least on their face, legitimate non-discriminatory reasons. And we did that here. So even if we assume this was a mixed motives case, which it was not, and even if we assume that the same decision defense is a proper statement of law under the Iowa Civil Rights Act, which is not clear, it would not have made a difference in this case because all of the evidence that the defendants would have used to prove this same decision defense was all the pretext evidence that we disproved and that the jury didn't believe.
I mean, looking at the overall tenor of the case, you may well be right. I mean, I think with the same decision instruction, you may well have gotten the same verdict. It seemed like the jury and the trial judge did not think a lot of the defendant's defense. But having said that, isn't that same decision defense, you know, something that we've recognized at least implicitly in Bowman and in McQuiston and elsewhere?
There has been discussion about Price Waterhouse being one method of proving discrimination under sort of general discrimination laws. There has not been a Supreme Court case in this state that has said, in this case, we are going to analyze the availability and the applicability of Price Waterhouse same decision. You've all done it with pretext for years, but there's been no more than mere mentions of Price Waterhouse and same decision. I want to address.
I wanted to ask you about the golden rule allegations that were
Sure.
made. There was quite a summary of some statements that were made by you in closing. Would you like to address that?
Sure, and I don't want to take too much credit for the closing argument, though. That was Brooke Timmer, lead trial counsel, who's also here today. Closing arguments cannot be taken out of context, just like this entire trial cannot be looked at in a vacuum. What defendants have done, to their credit very well, is chopped up the closing arguments and taken out all the parts that support their position and put those in the briefing. I would ask this court to go back to the transcript, read the actual argument itself. There is nowhere where Ms. Timmer asked the jury, put yourselves in Greg's shoes and decide how much you would want if you were Greg and this happened to you. That is a fine line, and it may be splitting hairs, but I think for purposes of the golden rule argument, that's an important distinction to make. She never implored the jury to say, what if you worked at GRMC as the lab director for 40 years and all this happened to you? You should award Greg what you would want if this happened to you. That did not happen. So I think the use of the word you is not inherently prejudicial, does not inherently result in a golden rule violation, and does not require reversal. Context is important. The other thing is some of the cases that we've cited, and I believe this court has echoed the same sentiment, is we trust juries to find the truth and to do justice. We trust that juries follow the jury instructions that are given to them. They are told that they're not supposed to award damages based on passion or prejudice or sympathy, and that they are to follow the law given to them. And if we are to honor Iowa's juries and respect the decisions that they make, we have to trust that they made these decisions based not on closing arguments, but on the evidence at trial that was before them, which again was that Greg Hawkins suffered from significant emotional distress damages as a result of his termination.
On that point, though, he didn't get any treatment, he didn't seek counseling, medication, no marital problems, et cetera. Is Jasper sort of the upper limit, 200,000? That we said that less than 10 years ago.
Jasper is actually distinguishable from this case. In Jasper, this court reduced emotional distress damages based on a relatively short period of employment. I believe she had worked for the employer 4 months. Here, Greg Hawkins put almost 40 years. I mean, this was essentially the only job he'd had. The other part of Jasper was, I think it was the plaintiff and maybe a couple of other witnesses testified about her emotional distress. We had 12 witnesses at this trial, including some adverse, talking about how this termination impacted Greg and how much his job meant to him. And in Jasper, they also focused on the fact that because the plaintiff was relatively young, she was able to find a job relatively quickly. So all of those things distinguish Jasper.
I understand. What appellate case law do we have that have upheld jury verdicts for emotional distress north of $1 million?
I think this probably would be one of the first, if not the first. To that, I would offer to the court that comparing verdicts is not terribly helpful, and this court has acknowledged that. We're limited, of course, by other opinions to whatever's in the opinion. We don't know what the witnesses did. We don't know what the testimony was. We don't know what the parties were like. And of course, all those things factor into how a jury awards damages, because they are the ones who are listening to the evidence throughout the entire trial. The judge is the one that is monitoring the evidence, monitoring argument, deciding whether things should come in or whether they're improper. The district court judge is the person who has the full context and not just little snippets on a piece of paper. In this case, when the district court judge denied the defendant's motion for a new trial, he commented on what he saw in the courtroom. He commented on what the jury saw in the courtroom. He commented on the evidence and the closing arguments, and he concluded this jury got it right. We respectfully ask that this court reach the same decision. No pun intended.
Mr. Armentrout, any rebuttal?
Yes, Your Honor. With regard to the misconduct, it's not just the golden rule violations and the use of the word "you." There was other misconduct which we have cited in our briefs, and to briefly summarize, there was also exhortations by plaintiff's counsel for the jury to punish the hospital. And that's clear from the comments we put in there. In fact, in the appendix at page 1972, plaintiff's counsel asked the jury and told them it's your responsibility as a citizen to decide how GRMC will operate in the future. That has nothing to do with the damages for Mr. Hawkins in this case. That asks them for a deterrence factor to deter the hospital not to do this. And again, that's a punitive damage type argument. A few pages later, counsel said, it is going to be up to you to decide how far employers like GRMC can go in violating our rules. And that's, of course, another deterrence factor. How can you prevent other employers from doing the same thing?
Deterrence, punishment?
It's part of the, yeah, it's part of the reasons we have.
Deterrence is part of the tort system.
It's certainly not part of a link to the damages that Mr. Hawkins has. And as we all know, there is no punitive damages under the Iowa Civil Rights Act.
I guess my question, I should be sharper on it, but punishment clearly is out of bounds. We know that. But the question is, what amounts to punishment in the punitive damage sense, and what amounts to accountability? Is the suggestion that a defendant should be accountable for what they do, is that impermissive argument in your view? That's punishment?
I don't know that crosses the line, accountability for violating the Civil Rights Act, if that's what's found here. But I do think these comments went beyond that. I mean, the last comment that was made was, you need to award an amount that you communicate that they will never do this again.
But if you look at the California case, you know, I call it a hybrid case. You know, one of the remedies is injunctive relief to stop them from doing it in the future. So that's one of the purposes of the Civil Rights Act, is to stop people from doing this in the future. I mean, I don't see that as punishment.
Well, at this stage, of course, we weren't in the injunctive stage asking the district court to come back and award an injunctive. In fact, that's an option that could have happened here with the plaintiff. In fact, they did come back and ask for attorney fees and that sort of thing after the trial, and they could have asked for injunctive relief, and that can happen. You can ask the court, if you prevail in your Iowa Civil Rights Act case, to take relief such as do something, train your people, do something with that supervisor who has been found to have made discriminatory statements or use those sort of actions.
Can you identify any specific violations of an order in limine during the closing?
Yes, Your Honor. I mean, we had some history with this plaintiff's counsel in the past, and so we had put together a motion in limine directly on the issue of the golden rule and discussed it. It's in the record with the district court to make sure that there was not going to be appeals to put the jury in the shoes of the plaintiff. And in fact, that's what was said at the time of the jury instructions. The plaintiff's counsel agreed that we will not ask the jury to put themselves in the shoes. Those exact words obviously were not used. I think that this court just came out with a Kinseth decision last year with regard to misconduct. And a very important part of that decision is the court should separate isolated or missteps made by counsel versus those where there was a specific design to use improper methods. And we think that's exactly what happened here. Plaintiff's counsel had a prepared script from which she read the closing arguments, obviously prepared well in advance. And so she didn't use the words "put yourself in the shoes," but used about every other way to use the same kind of analogies to ask the jury to put themselves in the place.
Let me ask this question. You're complaining about the amount of emotional distress. One of the tools we have is to do a remitter rather than reverse it for a new trial. What would you say? Let's assume everything else is okay, and we decided to remit it. What would you say we should remit it to?
Well, Your Honor, back in the Jasper case, the court did point out that there might be something such as longevity in the employee's past that might warrant a larger increase, and the court cited with approval the Gopher News case, Mathau out of Minnesota, in which case the plaintiff there had worked 30-plus years for his employer. That person did have some financial difficulties at the end, but the emotional distress award was $165,000, which this court said in that case was the correct amount. That person didn't have medical treatment. They still had the common consequences of job loss, but because of the long tenure, that was more appropriate than the $100,000 award that was reversed. I see that my time is up. The hospital would request that the court reverse this case and remand it for a new trial. Thank you.
Thank you, Mr. Armentrout. The case is considered submitted, and the bailiff will recess court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.